एक मिनट एक मिनट,
क्या हुआ?
अभी से इतना खर्चा करोगे तो मेरी पढ़ाई का क्या करोगे?
तुमने पहले ही लाइफ इंश्योरेंस का चाइल्ड प्लान सोच रखा है, इसके लिए।
सपनों को रखो सुरक्षित चाइल्ड प्लान के साथ। सबसे पहले लाइफ इंश्योरेंस।
Yes, please.
For the petitioner, the parties have filed the petition together. My lord may have that IA 211-627. There are certain cases pending, details of which we have given at paragraph 3 of page 3 of the application.
We have seen that.
And Lord, page 5 is the payment terms, and page 7 is the time to vacate the property. And Lord, my lord may allow the application not in between not the first semester fee which he has paid, he has reimbursed. He received. He have reimbursed. Not
The parties have.
so my client is also there logged in. My lord directly, he is online.
Yes.
He is online, and I believe the wife is here.
Parties have filed instant application, placing on record the terms of settlement. The usual order. Money, the payments and
So the terms is that by December 2025, 2 crore will be paid, and the rest 1 crore will be paid in.
parties abide to adhere to the terms of the
Yes,
SSC.
that will.
Parties undertake to abide.
Yes,
to the terms.
I-
They are present
Yes.
in the court. Mr. Das is joined digitally.
My client is there.
1 minute. Was I
Yes,
identified by, what's your good name?
Srijit Chakraborty.
Chakravarti. And Ms. Kanya Das, who's physically present in court, is identified by
Kaushik Kumar D.
parties who and counsel have been made aware of the consequences of the breach of the undertaking. So the payment as stipulated in clause 3 of the agreement, the terms of payment shall be adhered to. And insofar as the other terms stipulated in para 3.2 and 3.3 with regard to the location of the property And more so, the application probably shall be adhered to by the parties. This one. Then marriage is dissolved. Decree withdrawn.
When here acrimonies were between them has been resolved today with your lordship basis, we are extremely grateful to this.
Thank you very much.
Grateful.
The cooperation of the council and also the party. We have been able to see what weighs in our mind is that the burden of the judiciary is listened.
That.
Thank you.
Yeah, please. Service complete, but no one has filed their counter. No counter is open.
Yes, sir. What is
Service is complete, but no one has filed any counter.
Because this is a matter of competing claims between the deceased applicant before the tribunal and the respondent number 2.
Correct.
Now, an order goes, if the matter is filed in 1996,
Yes.
it dies in 2002, and order is passed in 2009 in favor of a dead person. That order is challenged by the respondent number 2. These are competing claims. Both of them were working in a college, in a private aided institution.
Yes.
And the grant in aid was the subject matter of dispute, which was granted by the state. Now, whether the deceased, the husband of the deceased, the husband who's dead now, whether he is eligible to get it or the respondent number
So
2.
therefore, what is the impugned order? Why have we issued notice?
Lord, the impugned order is that since an order is passed in favor of a dead person when he was dead in 2002, the order is a nullity. And that's the judgment of your lordship. I have the judgment of your lordship once I can pass it on, that against a dead person in favor, and whenever it is sought to be implemented, the person concerned can.
Yes.
And these are competing claims.
What do you say to para 6, sir?
Madam, let me explain. Madam. He is appearing on behalf of the state only. He has hardly any role with regard to.
No, but para 6, how do you?
Para 6, madam. Having heard learned counsel for the appearing parties, after going through the material and so on, it is found that applicant number 1/6 died in 07/4/2002 during the pendency of the matter before this court in OJC number so and so, which was subsequently transferred and registered GI case now in the position court is not inclined to substitute. My lord, please come to page. My lord, the answer is straight. My lord, please come to page.
Who are you?
Page 29.
Who are you?
Let me explain. There are three persons. I'm the junior clerk in the college. There are 3 persons appointed in a particular.
1 minute. Who are you? Who died?
I died. My husband died.
So the legal hours are to be given benefit.
That's what I'm saying.
That's the point.
Please come to page 29.
Uh-huh.
Please come to page 29. My lord, the learned tribunal. Madam, para 15. Para 15 at page 29, madam. Para 15. The learned counsel for OP number 5 has filed the death certificate of applicant number 1. It goes to show that he died on 7/4/2002. No doubt he has not been substituted by any of his heirs. But then his family members have to get the benefit which the applicant would have got had he alive till 7/4/2002. My eligibility was, let me explain. There are 3 persons appointed in a particular college. The particular college got approval of granting aid in the year 1996. All the 3 names were sent for approval. Me and another person were selected. The third person, who is appellant before the High Court, was the learned tribunal, after meticulously going through the entire document on record and their eligibility of all the three persons, finally decided me, my husband, and another person were supposed to be, two persons were supposed to be get the benefit of the grant in aid. The third person who challenged this in FAO by filing FAO in the High Court.
Mr. Misra,
Yes, sir.
whether this principle of a decree in favor of a dead person,
Yes, sir.
which applies to civil proceedings,
Yes, sir.
would also apply to proceedings in service law.
I'll just tell you about this. The first application was filed by him because the government.
That was allowed by the. Forget about that
I'll
application.
just tell you a lot. So because of
It means that some original application filed by the deceased husband of the petitioner, that was allowed by the tribunal.
No, my lord, there was no application for bringing on record the legal heirs.
Forget about legal.
Yes,
The respondent number 6, the husband of respondent number 6 or respondent number 6 moved an application
yes,
before the tribunal.
yes.
That was allowed.
No, my lord, there was no application moved. It was only informed to the tribunal, if your lordship will look at that order, that the applicant had died in 2002. And that is how the applicant passes an order that the benefit should be granted to him.
What order in his favor was passed by the tribunal?
Yes, my lord, your lordship will look at page 29. Now, the order granting aid in favor of the respondent number 2 was quashed by the tribunal.
The respondent number 2 is?
The respondent number 2 is the petitioner before the High Court. Now, there are competing claims. Now, your lordship will appreciate.
No, there may be competing claims.
এই রিলটা দেখেছিস? আরে এই ভিডিওটা দেখ, এটা এখন ভাইরাল। হ্যাঁ,
अरे तो ये रीलটা রাখ तो कईयों की सवारी चलती अपनी शान से हीरोगिरी छोड़ के तू कृपया जरा ध्यान दे रुतबा है ठंडा और सॉलिड है बंदा जिगरे की आवाज सुन
I'm feeling unforgiving. Fall out like a nuke, the place the skin on you is spinning. Craving the adrenaline, walk like my dog, you're never ready.
दुनिया देखছে তুই দেখা
Saying repeatedly that nothing was allowed when it was allowed in his favor.
In 2009.
Whatever.
Yes,
in 2009.
Yes, ma'am.
And therefore you are saying that it was passed in favor of a dead person.
Yes, ma'am.
And therefore legal heirs cannot be substituted.
I'll just go to the next point.
Only a question of substitution of legal heirs.
I'll just go to the next point. That this order was challenged by the person in whose favor granting aid was before the High Court.
Yes, we understand.
Now, these are the competing claims. Now, the respondent number 2
So why are you emphasizing so much?
will be prejudiced.
Why are you emphasizing so much about this competing claim?
Yes, ma'am.
Competing claim is not decided by the High Court.
No,
The High Court had only decided the substitution application.
The High Court goes on a technical.
Substitution application only.
Yes, ma'am.
You will allow it and send it back to the High Court to decide the competing claim, as you are repeatedly agitating.
My lord, my only claim is that
I'll leave it to your lordship.
only up to 2002 I am entitled. My lord, I am saying.
Allowed in today's date.
My lord, of course, I have a judgment if I can just pass it on.
Yes, yes, please.
Your lordship.
And we also both of us to file the written note of submission.
आप allow कर रहे हैं आपकी
I'm ready.
You just pass on the judgment. You just give the copies to us. Don't file written note. Copy of that judgment which you rely, just pass it.
My lord,
Today itself.
the footnotes and paragraph 22 is important.
Just 1 minute. Paragraph
22 and the footnotes. Any decision in favor of or against a dead person renders such
CPC proceeding. That CPC principle,
Yes, ma'am.
that is why I asked you whether that CPC principle of decree in favor of a dead person,
Yes, ma'am.
it applies to service law proceeding also.
Lord, my humble submission will
No,
be
not
that
submission.
when
Enlighten us.
that's what I'm saying.
Yes.
When there are competing claims, because again I'm repeating.
Again, competing
Again,
claim is not
competing.
decided by the High
Because
Court.
High Court has not
High Court
decided.
has only
But-
disallowed
but
the
tribunal-
substitution application.
The tribunal decides in favor of a dead person. So therefore, my humble submission will be this is applicable
So
to.
suppose there are two competing claims between two employees,
Yes.
and one employee dies,
Yes, my lord.
the other employee will automatically get the benefit.
No, my lord. The legal heirs can substitute themselves there, saying that the entitlement is of the deceased person. Therefore, we are continuing with the procedure.
We have understood. Yes, next.
Very grateful.
But I appear as amicus on behalf of the petitioner.
I am appearing for the respondent. This has a web of litigations. I could examine it yesterday. If my lords are kind enough to give me some time so that I can put a short note, my lords, along with some documents which they haven't filed. The petitioner hasn't filed, especially the misconduct proceedings, where, my lords, after evidence, it was decided by the court that there is misconduct on her part. My lords, I would want to bring that on record. It's in Marathi, and that is why sometimes.
We had requested you earlier also.
Yes.
Let me allow overall, please.
You want time?
I won't come in the way, let them bring whatever they, because lordships have given them last opportunity on 18 July. But be that as it may, let them file whatever they want to file. The record should come before your lordship.
On 18th of July, we had said no
Yes,
problem.
I went through that, my lords.
Otherwise, I have a note of arguments, but not basis what they will now file, I'll revise the note and
Share
file.
with me so that.
No, basis what they file, I'll revise the note and share it.
That is adjourned by 1 week. 1 week, ma'am. She's poor.
I understand that.
1 week. Rejoinder, if any, 1 week.
Grateful. Grateful. So deeply obliged.
Obliged. Grateful.
We request the council to fund.
Lordship, very deeply. It is a lordship. But I mean, some difficulty in the week starting 22nd September. Not if it's before that, there's no 22nd after. Very well. I grateful.
My lords, I was appointed as an amicus on the last occasion in this matter. I tried getting in touch with the respondents. I was not able to do so. However, I was able to get in touch with their local council. As per him, the respondents are very poor. Respondent number 1 is also suffering from some health ailments, and is therefore they do not have any means of coming to the Supreme Court.
Did you apprise them of their statutory right of legal aid counsel?
Yes, my lord.
Lord, the limited issue, Lord, is 3,700 days of delay, Lord, in Lord, the restoration of the appeal, which was dismissed for non-prosecution. Lord, the High Court excluded 726 days, Lord, of the interest, and Lord, 3,700 days, Lord, which was taken.
How much of difference would it make in terms of money?
Lord, 10 years, Lord, 10 years of interest.
You're only asking how much.
Oh, Lord, 6.
In terms of money, how much would that be?
Lord,
My lords, around 3 lakhs, my lord.
No, Lord, I'll be more than.
We just go out, if it is only 3 lakhs, they are poor people.
No,
We understand that the delay in approaching the court is something they have to explain. But if the learner, the amicus is already taken, stupid action. Just see what is the delay. What is the amount?
I'll just calculate it.
Just calculate.
Yes.
If it's just 3 lakhs, then we'll put a quietest to it.
Very well. I'll just calculate it.
Just pass.
Just calculate it.
In item 47, your lordships were pleased to issue notice to explore the possibility of settlement.
Yes, who are there? Yes, Mr. Counsel.
Lords, I am for the respondent in this matter of Lords.
Any possibility of settlement?
Lordship, the respondent always intend to live with the petitioner of Lords.
No, to mediation or no?
Lordship, if there is possibility, yes, Lordship, I am having the direction, I am having the instruction that...
May it be sent to Madras High Court Mediation Center, your lordship. It will be convenient for both the parties.
Madras High Court mediation.
Lordship and Lordship, I am...
Yes, mediation center attached with the Court of Judicature and Prosecutor.
Lordship, I am also seeking the permission to file my counter affidavit within 4 weeks.
First mediation.
Okay, Lords.
Mediation called.
Obliged.
48.
Yes, please. There.
Well, it's appearing. respondents clear moved a letter
For counter affidavit.
filing our counter.
Why? It has to be allowed only anyhow.
Well, it's
Now,
last opportunity.
1 week, is going to 1 week, list on, no further.
49.
In 49, Lord, this matter raises substantial question of law, Lord, that whether the government employee, Lord, if there is any dispute on the part of government employee in reference of the fixation of pay, whether he has any right not to vacate the government
So
premises.
you have a right.
No, Lord. The problem in this matter is, Lord, in 2003.
Yes, who's for the respondent?
Lord, I answer this. Lord, admittedly, my retired dues are.
No, 1 minute.
Yes.
See, dues were undisputedly, irrefutably, they owed money to you.
Yes.
And that was towards your retirement benefits.
Paid after 3 years.
Whatever it is.
Yes.
Do you have a right to retain government accommodation?
Lord, why did the High Court interfere? It's because of your Lordship's 2001 judgment, which is quoted by the learned single judge, that the fact that a government employee has not vacated the government accommodation is not a ground to withhold retirement benefits. So the High Court has taken note of the fact, because the government was writing letters to me, first you vacate, only then I will release your retirement benefits. Not that.
Where is that letter?
Yes.
Reply, where do you say?
Lord, please see the letter.
Reply, where is that letter?
Yes, page 37 of my counter affidavit. Page 37 of my counter affidavit.
No.
Yes.
In your reply,
Yeah. Yes, sir.
where is that communication of the government that please, only if you will vacate, we'll pay the amount?
My Lord, the reply filed by the state before the High Court has para 3, page 38. Page 38, reply of the state I am reading. Page 38 of my counter. Paragraph 3. May I read you? It refers to that very letter. What your lordships are referring to.
Where is that letter?
Lord, the letter is not on record, but it quotes the letter saying that you vacate, then I will pay. Please see page 38 for a moment.
We have seen page 38.
Yes, may I read, Lord? That the petitioner has been directed to vacate government residential house allotted number so and so, dated so and so, so that the department may issue a certificate of vacancy of the government residential house to the petitioner, and the petitioner can get pension. This is the stand of the state, and this is directly. Now, please see your Lordship's 2001 judgment, which is quoted by the learned single judge. Please see page 24. Page 24, single judge. Paragraph 6, Lord. Towards the last part, page 24. This is 2001, 6 SSC. Page 591. Now, please see the quoted part, my Lord. My Lords, have it, my Lord? Pension and gratuity are no longer matters of any bounty to be distributed by the government, but are valuable rights acquired and property in their hands, and any delay in settlement and disbursement whereof should be viewed seriously and dealt with severely by imposing penalty in the form of payment of interest. Withholding of quarters allotted while in service, even after retirement, without vacating the same, is not a valid ground to withhold the disbursement of terminal benefits. This is exactly what they have done for 3 years. 2013, I retired.
Why did you not vacate is what we are asking.
Lord, so therefore, my Lord, my respectful submission is, because they are also pari delicto, my Lord, they have also not acted in accordance with law, and they for 3 years